Hi, I'm Brian, the CEO of Perform Law, and in this video, we're going to talk about admitting new partners. The context of admitting new partners in a law firm really comes from, three distinct areas, if you want to think of it that way. One, as senior partners, for example, are exiting through a transition plan or just leaving the firm in the natural order of things. Generally, new partners come in, or existing partners take more of their units. That's one scenario that this is useful. Another is when a lateral hire comes in, and how do you make a lateral hire, and what are the issues with that? A partner. And then third would be, just organically, somebody's been with the firm and now you want to make them a partner. And how people go about this really depends on the structure and the age and the philosophy of the firm, and frankly, the value of the firm and in terms of a brand and in terms of systems and processes. So we'll talk about that as we go, but let's just start with the three main ways to admit new partners, or really issues that come up when admitting new partners. So, is there going to be a buy-in? And if there's going to be a buy-in, is there going to be a buyout? So one way to do it is no buy-in, no buyout. Okay, we'll talk more about each of these. Second one is book value with or without goodwill. The third one is to freeze book value and recapitalize the firm. And again, we're going to explain each of these in more detail as we go. So no buy-in, no buyout really works just the way it sounds. There's really no buy-in, so you don't get a buyout when you leave. Now, larger firms tend to use this because the firm has been in existence for a really long time, and partners come and go in the ordinary course of the firm's life, and there's an orderly transfer for equity. So no buy-in, no buyout probably makes good sense at that level. That doesn't mean there won't be required capital contributions. So when you come in, you may have to contribute an amount of money, either immediately or over time, commensurate with your interest in the firm. And that's usually dictated by agreement among the partners. And typically that's refundable when you leave. You get that back, whether you get it back at retirement, you get it back when you leave. And sometimes you get it back right away, sometimes you get it back over time. But generally the idea is you don't really buy into the assets of the firm. So if you were to leave the firm, you would be relieved of, you wouldn't really be able to say, well, I had a 15% ownership interest in the firm, so now I want 15% of the value of the firm. No buy-in, no buyout is designed to avoid that. Okay. So the next thing is book value with goodwill. Now you're getting into valuing the firm. Okay. So you start with book value. So it's assets minus liabilities, but you have to add in the accounts receivable and work in progress because they're typically not on the cash basis law firm balance sheet. It's a little wonky, but just know that the assets include the AR, accounts receivable, and work in progress. And then the partners, by agreement, add something extra in for just the essence, the value of the going concern, which is that, all this stuff is here, it's working, it's making money, it's worth something more than what's on the books. Okay. So real simple example, a law firm has 500,000 in assets, including AR and WIP. And let's say it owes 200 to the bank. Okay. The book value is 300,000. Okay. So you just take 500 less the 200 gives you 300. Now assume the partners agree to a going concern value of $50,000. Each share then is increased by $500. Okay. If you have 100 shares. So basically that is just by agreement that they agree that the firm has more value than what's on the books. Okay, and we'll talk about what makes up goodwill in a couple of slides from now. The next thing is book value without goodwill. Same exact idea, except there's just no goodwill. The firm is just valued on what's called book value, which is assets minus liabilities plus the AR and WIP if they're not already in the assets. And it's the same example. It's just 500. If you have 500,000 in assets, you owe the bank 200,000. The book value is 300,000. You have 100 shares. Each is worth 3,000. Again, just no no calculation for goodwill. All right. So what is goodwill? Here are some goodwill is kind of almost like anything the partners agree that is goodwill, meaning it's an intangible value that isn't captured in the financial statements. Okay. So if you look at these 4 or 5 examples here, so reputation of the current partners, it just might be worth more money in the long run to practice with the current partners than what's on the books. The second thing is firm name recognition and search engine credibility. So if a firm has invested a lot of money in building a brand and has spent a lot of money in developing search engine credibility, then that has value that supersedes really or transcends what's on the books, because that suggests that there's going to be future value in terms of business and things like that coming to the firm, good recruits, as a result of those investments. Okay, so those are future benefits. Use of current partners' creditworthiness. At times, existing partners who have been partners for a long time have had the ability to build up enough personal worth that they have high creditworthiness, and the banks look to that to guarantee any credit lines that the firm has. Well, if you're in a transition plan, for example, and senior partners are exiting and more junior partners are coming in, they actually may not have the net worth to carry the bank debt, for example, that would be associated with the transition if you're going to use debt for it. So, or just a simple working capital line to cover buying the partners out and startup costs and things like that. So you're going to need sometimes the current partners to stay on those credit lines. Well, then there's value to that. And so that could be considered goodwill, or it could just be interest. Then any marketing and administrative systems the firm invested in that will have projected future value, there could be some goodwill there. And then any key talent and staff. So it takes money. It takes a lot of money to build marketing systems out and good administration systems out, and it takes money to amass key talent and staff. All of that money is expensed in the periods that those investments are made, but those investments are going to pay back in terms of profitability. You're going to pay back for many years to come if they truly have value. So the argument is that that is not captured in the financial statements and ought to be considered in evaluation of the firm. So those are just 5 examples. There are others. The third method is to freeze book value and recapitalize the firm. So when this happens, the partners agree that we're going to, and this would typically happen when you're admitting maybe a block of new partners, or you're maybe doing a lateral, or you're doing a merger, or maybe a transition plan, where you would say, okay, effective 12/31 on a certain date, all of the AR WIP assets and debts of the former firm go to the former partners. Then you start over on January 1 with a new firm and you recapitalize it. Okay, so what I mean by recapitalize it is if all of the AR and WIP goes to the partners in the former firm, then somebody's got to put up capital, which would be the new partners have to contribute capital to cover any asset transfers, for example, if they buy desks and chairs from the former firm or computers or whatever, and any startup costs, because there won't be any AR and WIP coming in because all of those monies are going to be going to the former partners. So this one's a little trickier. It's done. We've done a couple this year. It's done. It can happen. It's just a personal preference, and each of these situations sort of takes on its own characteristics. So now, just briefly, how much equity do you allocate to new partners? I mean, what are some ideas to do that? So there's some concepts here. Okay, so it matters more when compensation and equity are linked. So if your compensation is related to the equity you have in the firm, then you have to get the equity at such a level that you're fairly compensating in any of the partners. That's just a lot trickier to do that. If compensation is independent of equity, a smaller percentage is offered initially. So if compensation and equity are separate from one another, and my compensation doesn't matter how much I own. For example, if I really produce, I could make more. If I'm a junior partner and I really produce, I could actually make more than a senior partner. that how much equity I have, how much equity, a lawyer has in a firm is less important because it doesn't dictate compensation. Now, generally you're going to want to line up equity with somebody's economic and other contributions to the firm, just because will keep the law firm healthy, and that will allow people who are contributing to at least influence or to have a greater influence over the future of the firm. So what we like to do here is to see a vesting in new percentages on a 2 or 3 year period based on profit contributions as one metric. You could add maybe one or two others, but in general, what I'm saying now is if somebody on a consistent basis over a 2 or a 3 year rolling average period, for example, contributes 30% of the profit, then they ought to have pretty close to 30% of the equity. Okay. Now, this can be a challenge because, especially in new firms where senior partners have actual legal control of the firm, you have an orderly transfer of equity and the junior partners are growing and growing and growing. Eventually, their equity interests are going to put the legal control of the firm in jeopardy for the senior partners. And that's just a bridge that's difficult to cross the first time. But once you do it and you have an orderly transfer of equity, then the firm can perpetuate. These are all a little bit difficult to do if you haven't done them before. But once you do them and you have a good system in place, I think, what we've seen is it makes for a healthier firm. So the last point here is that if compensation and equity are linked, a buy-in type approach with an economic contribution analysis is needed. So if my compensation and my equity are linked, it's going to be really important for the firm to get to get my equity percentage to match my economic contribution on some level, or else I'm either going to be overpaid or underpaid. If I'm overpaid, it's going to be a problem in the firm. It's going to create morale problems because it's going to mean someone else is underpaid. If I'm underpaid significantly enough, I'm going to leave and go to another firm typically. So those are, just 4 or 5 concepts and things to consider when admitting new partners. Again, we do a fair amount of this. If you're watching this because you're about to work with us and you're watching this as part of a new client orientation, then just know that we're going to come back. We're going to talk about this. There are lots of different ways to nuance this. There are lots of options and ways to do it. But these are the basic ideas. These are the things you need to think about. That's it for our presentation today. Thank you for tuning in. I hope you found it helpful. If you'd like additional information about admitting new partners or a number of other law firm management topics, just visit performlaw.com. You can contact us at 504-858-7428. Again, thank you for spending some time with us today.